Hey everyone, welcome back to the channel. Today's video features a whole lineup of courtroom chaos, each person stepping up to represent themselves, with predictable results. We've got a sovereign citizen in Judge Perkins' courtroom, a self-proclaimed legal expert who's barely into law school but somehow knows it all, and to wrap things up, a Karen and Kevin duo that truly steals the show. We'll kick things off with a sovereign citizen in Judge Perkins' courtroom, as this marks the conclusion of a case I've been following for quite some time. Let's get into it.
City of Detroit versus Contrell Grigsby, case number SP 1683392. SP 1683393, counts 1 and counts 2. Appearance on the record, please. For the record, please. Mr. Grigsby.
That's Barry Jr.
I don't believe that's Mr. Berry. I don't believe that's necessary. I don't know, Mr. Grigsby. Do you want representation or no?
No, sir.
State your name for the record, please.
Special appearance, Contrell Grigsby.
Okay, good morning to you, sir. Today is the day and time set for a final pretrial. Set for a jury trial tomorrow.
Can I ask a question?
You may.
Since the last time we spoke, you told me to just bring all my paperwork down there. I wanted to see that you received it. I had brought it down to the courtroom.
I don't really know if it's going to be necessary. I also told everybody that all parties need to appear, and as their Valenstein is here. So no, I didn't get any of your paperwork that I have at the moment. Do you have brokerage? No. And what should I expect to see in that or read in that paperwork?
Should I brought my fee schedule down there. I made me an affidavit, conditional acceptance, and I brought a few things down there.
So let me make sure I understand this. You showed up with your conditional acceptance and your little fee schedule in hand? At this point, you might as well staple on a note from a neuropsychiatrist, because you'd have to be completely detached from reality to think the public is footing the bill for your nonsense.
I had last time we talked, you had gave me a lady's email address, and I also sent all the paperwork to her email address.
That's probably important. Officer Valenstein, good morning to you. Can you, we're on the record with Mr. Grigsby. Can you state your name, department and badge number, please?
Yes, good morning, Your Honor. Officer Valenstein, Detroit Police Department, badge number 4744.
All right, very well. Today is the date and time set for a final pretrial. So we do have all the parties here. There's going to be a jury trial tomorrow. I'm imagining that trial is going to go. I would like to have Ms. Schneider here to make sure that you two agree on any jury instructions. I don't know if you've made any, if you've gone over any jury instructions and have an agreement on the jury instructions and things like that. Or we'll just read the instructions as they are listed in the, if you have not. So I'm going to wait until Ms. Schneider comes in. Mr. Grigsby, I'm going to put you in a breakout room with Ms. Schneider. You two can have that discussion, and then we'll get you out of here. I'll wait till she comes back. We'll get you out of here after you talk to Ms. Schneider about how you two are going to proceed. All right.
Okay, cool. Yes, sir.
All right. So aside from the usual fee schedule theatrics, there's really nothing else worth mentioning here. After that, the prosecutor returns and they head into a breakout room to discuss the details of his upcoming jury trial.
Let's go back on the record with Mr. Grigsby. Ms. Snyder, can you put your appearance on the record, please?
Morning, Your Honor. Alexa Schneider for the people, P80322. The issuing officer is present.
Yes, I've already spoken with him. So have you and Mr. Grigsby spoke about procedure tomorrow?
Yes, Your Honor, we did discuss it. I sent you a chat. Mr. Grigsby has not prepared jury instructions, but he does have a civil infraction along with his misdemeanors. I talked to the officer. We're going to dismiss the 2 misdemeanors. He can proceed with a formal hearing on his civil infraction.
We're not going to call a jury in for that.
Correct.
What about right now? Mr. Grigsby?
Yes, sir.
So you can either pay the 145 and then we'll close it out, or you can have a formal hearing on that. The officer's here right now on the expired.
I'm having I want to have a formal hearing for Mr. Grigsby.
All right, are you ready to proceed now, Officer Valenstein?
Yes, Your Honor.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, it's on you, Officer Valenstein. You want to assist Ms. Snyder or not? I guess not.
Yes,
Go.
I'm
I'll
all
leave it
forward.
to you, Your Honor.
Say that again.
I'm sorry, I cut out. What was that, Miss?
I was going to say, I'll leave it to his honor.
Oh, okay.
It's up
So,
to you two. I mean, it's a civil infraction of expired plates. Go ahead, officer.
okay. Back on February 19th, 2025 at approximately 6:29 p.m. I was doing traffic enforcement in the area of Grand River and West Grand Boulevard. I seen the silver Chevy driving southbound on Grand River. I did a traffic stop, or I ran the plate, came back that it was expired. Back on December 21st of 2024, pulled the vehicle over, conducted a traffic stop. The driver, Mr. Control Grigsby, stated that, there was no registration for the vehicle.
So you're saying that he admitted that there was no registration for the vehicle?
As far as I recall, yes. There was no registration to show. I mean, as far as everything else, I don't know if you want me to keep going about the insurance or the display license, but.
No, I don't think that's relevant now, because that's gonna be. So basically, on this date and time, you pulled the vehicle over and the vehicle, for your testimony, the vehicle did not have valid registration, and that you're saying that Mr. Grigsby told you that the vehicle did not have valid. Go ahead, Mr. Grigsby, if you want to say more.
Yes. According to
Let me swear you in. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth? Raise your right hand, please.
I want to.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
As long as I'm not giving up any of my my rights.
No, you're not giving. You're just swearing to tell the truth, whole truth, and nothing but the truth.
Okay, cool.
Say yes or no.
And as long as y'all know I'm in special appearance, yes.
Do you swear or affirm to tell the truth, whole truth, or nothing but the truth?
Yes, sir.
Okay, go ahead.
Yes, sir. According to Michigan law, I'm only supposed to have my license or anything, license, registration, or insurance if I'm doing commerce, and I'm not doing anything. I was just traveling. I wasn't as I told the officer I was traveling. I'm only supposed to have a driver's license if I'm like making money or doing anything. I wasn't in, like I told him. Same thing I'm telling you.
So you're not disputing the fact that you're not disputing the fact that you didn't have plates on the vehicle, proper registration for the vehicle.
I'm disputing I'm disputing the
I'm
fact.
asking you a question. I'm asking you a yes or no question.
I'm asking you a question that is,
No,
do
you
I?
don't ask questions. I ask the questions.
Well,
So, do you, is it, is
Mr. Owens, the mute your device, please.
did you tell the officer that you didn't have any plates on the vehicle?
I don't recall what I told the officer.
Okay, well, he seems to recall very well. Is there anything further?
Yes,
Go ahead.
Michigan code. As I sent to you, I brung down there and I emailed the lady. Michigan code says that I do not need to register my vehicle. I do not need to have a license unless I'm acting in commerce. And I was not acting in commerce as I told the officer plenty of times. I'm not acting in commerce, so I don't need a license or I don't need to register anything.
All right.
Michigan.
Is that it?
Oh no. And I sent you my I sent you my conditional acceptance twice. I sent you all of my paperwork.
I'll let you put it on the record. So I'll let you put it on the record. Is that it?
Yeah, I want to put all my paperwork on the record. Did you receive it?
No, I told you I didn't.
Well, I don't know how. I got the
in this case, I'm gonna tell you this, I don't have to. Find you responsible, $145. When can you pay?
I'm not paying it.
You know, your right to remain silent doesn't stop at courtroom doors. And when it comes to fighting traffic charges, it's often the most powerful tool you have.
All right, bye. Have a great day, sir.
Yeah, y'all will be hearing from me. You'll be hearing from me, my boy.
$145.
It is.
I'm not your boy, all right?
You want to be.
I'm not your boy, okay? So don't say too much more, sir. I'm just saying you're free to leave. Have a very good day.
You always dress appropriately for court. I appreciate that. No, that's good. All right. So what's going to end up happening? We're currently in a jury trial, so I can't do jury trials at once. I've done that before, but the staff is like, Stephanie, it's too much. Yeah. So what's going to end up happening is your case is going to be recalled for another trial setting. And you have a choice. You can have a jury trial or you can have a bench trial. Jury trial, 12 people will hear the evidence and they'll make a decision on whether you're guilty or not guilty, or you can have a bench trial. Okay. A bench trial is where I hear all the evidence and I make a decision. What I can tell you, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. So that's something for you to think about between now and your next court date, okay? Okay. All right, so let me do this first. We're going to go on the record. Court is calling 2024 CR 009936, State versus Carrie Lampkin. Are you Carrie Lampkin? Yes, sir. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, you can lower your hand if you'll state your name for the record. Carrie Lampkin. All right, I'm going to ask you some questions, and the questions, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself, okay? Okay, it's like qualique. This is a qualique. A what? Qualique, to see if I'm able to represent myself. Yes. Okay. All right, so how far did you go in school? I'm currently in school right now. Should be graduating next year, but now that I'm now getting behind with finals because of. All right, so here's the thing. The best thing about being a witness and what attorneys always tell witnesses is just answer the question that's asked of you. Okay. So how far are you in school? I'm in college now. All right. What year? I'm considered a sophomore/junior. All right. And what are you studying? Law. All right. And how many years have you studied the law? I'll say about 5 years. This time I'm going to ask it and you can answer it. If you don't want to answer it, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer it. Do you want an attorney appointed to you? Yes or no?
Under pressure, I don't understand.
All right, that'll be no. Ms.
Respectful.
Ferguson, place this on the jury trial with Judge Angelini on June 16th.
So I'm not able to talk, Your Honor.
Sure, you can talk. Go ahead.
So I have placed on the record, Your Honor, substantiating evidence of the proof that I have not been able to receive discovery. On May the 3rd, May the 3rd, I have received the email of some more discovery that my attorney sent me after I filed a motion to withdraw from him. The only reason why I filed this motion to withdraw from him is because of the lack of discovery since day one. You know, Your Honor, every time we came here, it was, oh, Your Honor, the file's too big. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he has to come in and buy a hard drive. Like, he made me as his client get a hard drive to go get it, and he still didn't give it to me in a hard drive. Your Honor, I have substantiating evidence to prove my facts, and I have submitted it. I have filed it in the clerk with the clerk. So if he's willing to say what he said to you in court, that he sent me discovery, I would love, Your Honor, if he could do a sworn affidavit statement stating what he said, so it could be put into.
He's an officer of the court, so he doesn't have to do a sworn affidavit.
Yes, I understand, but I put the burden of proof. I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery until Saturday, 2 days before trial, 2 days before court date hearing. If you can look in the system, you'll see an affidavit statement signed by a notary that I signed under perjury, under sworn, I swore in, and under perjury. I'm not trying to go to jail over lying. I'm telling the truth, Your Honor. He did not give me discovery until it was a Saturday, that Saturday before court.
What exactly were you expecting? The entire yacht club to sail into court. A yacht club is a corporation or some form of business entity. That means it has a registered agent designated to receive service of process and an attorney to handle legal matters. If you're going to sue the yacht club, you need to serve the proper person and be prepared for a lawyer to show up on their behalf in court.
Your Honor, may I speak to that?
In a moment, let me ask this question. Has the sale of this boathouse actually occurred or not?
I have no knowledge. I have no access to the boathouse. They have the keys.
All right, I'm asking Mr. Berner.
Oh, I'm sorry.
It has not. Still titled in the Isaacson's name.
All right, Ms. Isaacson, go ahead.
In November of last year, I hired Joel Peñar to help us try to mediate this situation. And this is the attorney that we were speaking to. So he's well aware of what's been going on. He also was informed by Joel. I informed the court last time we were here that this is the attorney who was informed about this small claims court, yet they didn't show up the last time, even though I had tried to get service 28 different times through a service company. I did get service finally through the Secretary of State, and Mr. Peñar had suggested I go through small claims in order to try and expedite this because there was this attorney keeps increasing both the funds we owe and there's no it doesn't even make sense what this attorney wants. So I can't move. I can't have access to the property. I can't make any moves until something is done. Even though the property's in my name, I have no access to it.
All right. Two problems, Ms. Isaacson, with this. Okay. First of all, your claim is for money damages here. You're claiming that at least as I read it, that the boathouse was sold for $25,000 and you're wanting some portion of that returned to you. Mr. Stolarik did not sell that property. He didn't have title to do that. So you're making him the defendant in this case, even though he may have spoken to you about this and so forth. He's not the proper party defendant in this case. Looks like it's the yacht club that's the appropriate party defendant in this case. So that's number one issue, that there's not been proper service on the yacht club, even though Mr. Berner is here on behalf of the Yacht Club today. Second issue is what's the jurisdiction of this court in relation to the property that you're talking about? Mr. Berner makes a good point that this court only has limited jurisdiction in this matter, and for property that is owned with the title in this way, real property, so to speak, this court does not have jurisdiction in that matter. And he quoted the RCW that deals with that. It's RCW 3.66.030. Now, I can't, as the judge in this case, I can't decide to give you legal advice as to how to proceed with this thing further. But what I'm obliged to do at this point is to say that this court doesn't have jurisdiction in this matter for two reasons. Really, number one, the wrong party defendant is listed here. Mr. Stolarik is not the proper party defendant. And number two, this court doesn't have jurisdiction over this kind of case, so to speak, when you're talking about real property or what is considered real property. So I am going to have to agree with Mr. Berner to dismiss this case. Go ahead, Ms. Isaacson.
May I ask a question? I sued us, Mr. Stolarik, on behalf of the Olympia Yacht Club. He is a board member of the trustees and would be responsible for decision-making of the club. And he did not show up. He just sent an attorney. That doesn't seem like it's proper within the court, but I don't say there's no attorneys that should be present in the court. In addition, it's not just a complete where we own the property. According to the Olympia Yacht Club, they lease it from the state of Washington. They lease the property, and then we purchase the property through them, and we only have access because they allow us to have access. So I don't understand if they have a lease, but we buy the property, what jurisdiction it would be under, because they're leasing through the state of Washington, and they're not following some of the rules of the state of Washington. So wouldn't it be this court that I could go through? Your Honor, my husband is available to help me. He's not an attorney, but he did go to law school and he's ill, but I can bring him in to maybe help clarify some of the things about our club. He is the part owner.
Here's the problem.
A little overwhelmed by the attorney.
Thanks, Your Honor.
Here's the problem, Ms. Isaacson.
Wait.
Mr. Stolarik is, as I say, not the proper party defendant in this case.
Your Honor,
he may be on the board of directors, but he didn't sell the property. He doesn't have the money. The property hasn't been sold. Much of what you're arguing about here in this case, hold on. Much of what you're arguing about here hasn't occurred yet. It hasn't been sold. And you're asking for money from from a transaction that has not occurred. We're getting far afield, Ms. Isaacson, Mr. Isaacson, we're getting far afield in the merits of the case. We're not going to get to the merits of the case because this court doesn't have jurisdiction. There's small claims court, there's district court, there's superior court. Each of them have different levels of jurisdiction, matters that they're allowed to discuss and make decisions on.
Your Honor, may I speak, please? Your Honor, may I speak?
You have been, while I've been trying to speak.
I haven't spoken up about attorneys. He's misrepresented the case, Your Honor. I've been listening on my bed, upstairs to the attorney. He's misrepresented the facts. He's misrepresented the actual law that represents the situation here, Your Honor. It's not RCW, whatever he claimed. And also, Your Honor, I want to say something about just proper decorum. This is not trial by ambush. You don't bring an RCW into a court and waylay some poor lady, my wife, who's not an attorney, without providing that to her so she can review the law and have a rebuttal that's appropriate? You can't do that. It's not proper.
I think it's becoming pretty clear why you're not actually a lawyer. And what are you even trying to say when you claim attorneys aren't supposed to cite court rules in court? That's literally part of their job. And let's not pretend this is some personal attack on your wife. You're the ones who chose to file this case in the first place.
So I'm saying that you can't have an attorney in district court. One, you do have jurisdiction, Your Honor, and I can argue it very well if I can see the law. I can do it. You have jurisdiction. So what I would say is that if this attorney is able to sway the court and be persuasive, I would ask that this be continued so that I can go research the law, provide a proper rebuttal, because the reality of the property is this. The property literally is owned by the Olympia Yacht Club, and pursuant to their bylaws, we are allowed as an outside party, not a member of the yacht club yet, to make a purchase of such property, but only on approval of the Olympia Yacht Club board and their laws and bylaws. They are the party to this lawsuit. They got it. The whole argument of this lawsuit, Your Honor, is a breach of contract. The Olympia Board of Trustees got into a contract with me and my wife to purchase this property or sell it. We have all of that in our records. It's all in front of the court. The court has the jurisdiction to have a breach of contract claim, and also this court has jurisdiction to hear interference with contractual relations. Those are the issues before the court. The court we are arguing that the Olympia Yacht Club created this whole controversy, created this problem for us. We can show it by the facts, created a contract with us. We have all of the 4 prima facie elements for a breach of contract claim. They built a contract with us. Ed Stolark was the representative of the board for the creation of that contract. He is the one who has standing to this court. We have proven standing. We've proven jurisdiction. The attorney is speaking over Mrs. Isaacson and not allowing her to properly argue this case as if she were an attorney. That is not fair, and it's not what this district court was designed to do. We know this. So I'm asking that if the court would kindly allow us to get a continuance so that I can put all of what I just said into a properly articulated document with the proper exhibits. I'll be happy to do that, Your Honor. But my God, I've got liver disease. I'm on the UNOS patient list. I'm about to. It's been a rough winter, Your Honor. I will do my best to put that all together, but frankly, don't dismiss the case. I'll get 30 days to respond to the attorney. You do have jurisdiction. He is not properly doing this. He is the attorney who mucked this all up in the beginning, just like Mrs. Isaacson said. This literal attorney, has acted, in my opinion, in bad faith, and we have documentation for that, Your Honor. Please do not dismiss this case as misrepresentations of what is jurisdiction and what are the facts of the case and what is the justiciable issues in this case and who has standing and who has the right to bring the case before this court and also to ask for this court for proper relief. And all of that is here in this court. You have it, Your Honor. I can bring it before you and I can argue it properly. Please do not dismiss.
All right, Mr.
Unfortunately for you, Kevin, all the begging in the world isn't going to fix this. With your very limited understanding of how any of this works, you didn't even manage to serve the correct legal entity from the start. Normally, this is where I'd suggest hiring a competent attorney. But it looks like the Isaacsons already think they've secured the services of one of Washington's finest almost lawyers.
Mr. Isaacson, enough. I'm sorry that this is such a problem for you and it's upsetting you, but saying it over and over again doesn't make it so. What I'm finding is that Mr. Stolark is not the proper defendant in this case. The Olympia Yacht Club is. He doesn't own the property. He doesn't make all the decisions. The yacht club and the board of directors or whatever make those decisions. He doesn't. So it's not properly served on him. That's number one. And number two, I have real question as to whether or not this court has jurisdiction over the property. You can argue all you want about that. You can look at the statute as well. The burden is on you as a plaintiff when you're filing this to understand those things when you bring them forward. In a small claims court, all Mr. Berner has done is raise two legal issues, nothing about the facts or the merits of the case. One is service, second is jurisdiction of the court. It's appropriate in this instance on behalf of the Olympia Yacht Club, which has been improperly served, but is aware of the case. Obviously, from what you've told me, that you've had discussions with him in the past, that's fine. The Yacht Club still has to be properly served in order to be held to account by a court, whether it's this court, district court, or superior court. What I'm telling you is this court doesn't have the jurisdiction to do that. Number two. Number one being that Mr. Solaric is not the proper defendant in this case. So I am going to dismiss this action. If you want to look at this further, Mr. Isaacson, and make your case, you can do that. But we're not going to continue this indefinitely. Apparently, this is the second effort at this case. Maybe the first had a problem with service. I don't know what the issue was there. I'm not looking into the merits of the case. I'm looking at the legal approaches to bringing this case in the first place. So that's it. We're finished with this. Okay.
Under how are you dismissing it? With prejudice or without?
Without. If you want to refile, go ahead. But
Thank you,
Your Honor.
Remember the issues that Mr. Berner has pointed out.
You made them very clear to us. Thank you, Your Honor.
Thank you, Your
for
Honor.
your kind consideration of this case today.
Thank you, Your Honor. I would just request that the Isaacsons return my calls or return my letters. I represent the Olympia Yacht Club, the represented party. They know that. They should contact me.
Your Honor, that's very deceptive.
All right, that's all. All he is making a request. He doesn't need a response to that.
We don't have time, Your Honor. That's very prejudicial to us.
Thank you, Your Honor.
Thank you.
Thank you. That's all.
Call our attorney, Joe Paneer. The court now knows who to call. I'm sorry, Your Honor. It's very upsetting to hear what has happened today. And the other attorney has been disingenuous to this court, and I have to put it on the record.
I'd say he's being about as disingenuous as you are. The bottom line is this: you misfiled your case and you lost. That's how it goes. Take the lesson, learn the actual law, and if you decide to refile, make sure you serve the correct party this time. And most importantly, consider replacing the almost lawyer with someone who's actually licensed, assuming you're ready to listen to one. All right, everyone, that wraps up today's video. If you enjoyed it, hit the like button. If you didn't, hit dislike. Either way, drop a comment below and subscribe with notifications turned on so you don't miss any future content.